So there's been some kind of odd news that's come up in the last couple weeks, like three things in particular. One, you had this quote-unquote insider trading, alleged insider trading that happened internally at Coinbase. You had one of the initial promoters of Litecoin sell his stake in Litecoin under a quote-unquote conflict of interest. And then you had John McAfee come out and publicly sort of rah-rah or support Vergecoin, which is a great coin to get into, but it caused a huge surge in price, among other things. So the question becomes, using traditional securities law theories for insider trading, can they be used, and can you actually commit insider trading within the context of cryptocurrency? And it's a really complicated question. I don't think the way the law is written today, you can do it. And you have two concepts in securities law as it relates to insider trading. One, you have the classical theory, and the classical theory is corporate insiders, officers, directors, major shareholders becoming aware of material non-public information and then taking advantage of it by trading, whether that's buying or selling, right? Whether that's knowing good news and going and purchasing in advance of the good news, or knowing bad news and selling in advance of the announcement of the bad news to minimize losses. Okay, and so then the alternative theory to that is the misappropriation theory, right? And that doesn't deal with officers and directors. That deals with certain third parties, such as tippees, right? Someone who gets a hot tip, someone who's lawyers, consultants, anybody who is given or receives material non-public information and has a duty to not act on that information. And it's the same thing, right? Where that individual's in possession of the material non-public information, takes it and then trades for their own benefit, again, win or lose. That is insider trading. So you have two issues here when you think of like traditional cryptocurrency, you think of Bitcoin and Litecoin and the like. Well, one, you really don't have inside information in a sense that it affects a market. We're not talking about a security, right? It's clear that, irrespective of the ICO world and what that's happening there, and I'll get to that in a second, you've got Bitcoin, Ripple, Dash, you name it, and those clearly are participations in the economy. Those aren't securities. So the question becomes, if you're not acting on a tip that's related to a security, can you commit insider trading? And by definition, you can't. At the same time, are there really insiders, right? I mean, Bitcoin's a great example. We don't know, right? There is no real insider. Even with something like Ethereum, you have the developers, you have the promoters, but it's open source. So, and everything is very communal, right? It's very difficult to really find material non-public information or be in receipt of that and then act in accordance with it. So, the traditional definitions don't work really well. When you're talking about ICOs, if you have an ICO that, that token is a security, then that would qualify. The traditional definitions, whether that is as an insider, officer, director of the company that's promoting it, or certain third parties, such as an attorney, such as an accountant, such as even marketing people, to the extent that they know something is or isn't going to happen that's going to materially affect the price of that token, and they act on it, well, that would be securities fraud, because you are dealing with a security, you're dealing with a corporate structure, right? The ICO issuer, you're dealing with all these elements that would exist. So I think for your traditional coins, you see this sort of like promotion, and there's some, there's different rules that sort of apply to that, but the reality is, in a decentralized environment, no one could really manipulate the price based on material non-public information, and there's no center infrastructure that would allow you to get that, right? It's just a matter of your own digging. In the ICO context with the security token, absolutely. I think you are 100% opening yourself to liability for trading on internal information that would have a significant effect. As it relates to Bitcoin, because we do have that ruling from the CFTC that Bitcoin is a commodity. Now you're seeing Bitcoin futures. Right, there is price manipulation, which is a civil penalty under the Commodities Act, which I'll address in a later video. But the reality is, from a straight security standpoint, the application of it and how Coinbase thought that they needed to do it when they're not the issuer of anything, much less Bitcoin Cash or even Bitcoin, and there was some manipulation. It was a non-starter for me. It didn't make a lot of sense to me. It seemed like it was some kind of cover for something else, and if anything, it may have been some type of price manipulation that would really fall under the ambit of the CFTC, not the SEC, and the Commodities Act, which is, quite frankly, far less policed than insider trading and securities fraud are. So check me out. Check out my YouTube page. I'll have another one up here following up on this, and visit me, bitcoin-lawyer.org. Take care.